Welcome everybody to this live Melly trial day 4. Please everybody take your time, share this video, hit the like button so you know when I go live. Hit a comment down, guilty, not guilty, or hung jury. Here come the judge. Let's get it, baby. The judge out early today. He was like 40 minutes late yesterday.
We're off Monday?
It's a holiday.
Then we're off.
You can come.
No, that's okay. I'd like to extend that holiday to Tuesday and Wednesday. Can we vote on that, Judge?
You can.
Will the vote count?
I know
It's
the
more
vote-
important.
I know the vote you get. Thank you.
I want to make sure.
Melly look like he just chilling though. Yeah, man. He ain't even worried. Well, you take some stuff though. Well, I'm crying every day.
Fair enough. I wish I knew.
But I think he's
Partial affirmative.
real talk. I think
Can't reverse this.
You know, Kevin.
Don't jinx it.
I know.
All right, let's go on the record, please. The state of Florida versus Denman, president is the defendant, his counsel, and the assistant state attorney. The jury's in the jury room. Is there something you want to discuss, counsel?
Yes, Your Honor, I think there's a bunch of stuff we're probably discussing.
Can we first approach very briefly?
Sure.
Do I need to bring anything?
No.
Gentleman in front of us. We'll check on the jury, see if they're ready.
I thought there was other issues defense wanted to address.
There
Before
are.
we get started?
There.
I'm just bringing the jury in, so tell me what your other issues are.
Ready to.
No, tell me what the issue is.
The issue is we got presented this morning with a host of chat downloads that were purportedly downloaded from the chat account of whom the state purports to be Mr. DeMond's chat account. Before she introduces any statements, I think she needs to establish the relevance of it. This is just a download of a series of conversations, and putting them in en masse is a problem. Putting them in individually would require her to establish the relevance of the particular statement she seeks to introduce before introducing it. Our initial review of the contents that she wants to introduce shows relevancy problems, shows authentication problems, and shows prejudice and hearsay problems. So that's what we wanted to address before. We have a copy of what we're presented with here, and maybe we could present it to the court so you can take a look.
I haven't seen it taken a look at it. When do you anticipate presenting it?
Shortly after the first witness, but it's a business record on that. This is, and just so it's clear, this was provided as the initial discovery exhibit that was presented to defense counsel at the initial first ever discovery filing, and that was consistent. You will tell me the exact date on that, but I believe that was approximately March of 2019.
So let me ask you this. I haven't seen it. How many exhibits are there? How many are there?
This one is not particularly voluminous. There's a handful of pages, and then there are some video clips and some images. With regards to the images, I brought that to defense counsel's attention because there is one image that is on the defendant's Snapchat account that references some of the more inflammatory song titles. So I was going to tell them I'd be happy to hide that file so that the jury would not be able to access that or see that.
Okay.
And so I can provide those to Your Honor in the printout.
Sure, has it been marked for identification?
It has not yet.
So why don't we have it marked for identification? And is it possible that you do this or introduce these after lunch so we have a chance to look at them?
No, Your Honor. That's not for time frame on that. Like as I indicated yesterday, due to one of the witnesses having COVID, we'd probably have to end early this afternoon, and I beg your indulgence on the time and scheduling on that.
So, there's an objection, I need to review it and see what it says, so after, who's the next witness? Yeah.
Tara Kelso, the RJ Lee.
So we'll talk about it after, just have it marked as an exhibit, and if you could, just give a copy to Travis after it's been marked, and I'll see if I can take a look at it as we're going, all right?
Understood.
But you said there's videos as well?
Yes, Your Honor. So there are
You're
videos.
objecting to these videos?
On relevance grounds and authentication.
You know, when we take a break, I'll look, you just play it, we'll see what they're,
They're relatively short on the videos. So.
all right? And you were indicating that these social media are all from the defendant's account or something like that? Where are they from?
These are from the defendant's Snapchat account, Your Honor. And so I'll have it marked as states J for identification purposes. Presenting to Travis a copy of the business records authentication and certification, a copy of the printout of the chat records that are in a table format. Everything is contained on a USB. I'm also presenting a printout of all of the photos that were associated with the account, as well as a copy of with the photo that could be potentially an issue on the name of the songs taken out, and a copy of printout of the first part of the initial clip or the initial frame of every one of the videos on there.
And you intend to play all of these videos to the jury?
Yes, Your Honor, because the defense is contesting whose account that is and whose phone was using this, so that's the state's initial relevance argument.
Thank you. And it's all the same Snapchat account?
It is.
Thank you.
Your Honor, as an initial, just so that you know, a Snapchat account, I'm not sure how familiar you are with social media, but a Snapchat account does not identify a device because it can be accessed from your computer. So I don't think that would be relevant to demonstrate.
Thank you. Let's bring the jury in.
Jury is coming in, baby.
Jury entering. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, Mr. Demons, his counsel, the assistant state attorneys, and the ladies and gentlemen of the jury. Ladies and gentlemen, I hope you have a nice evening, and I think we're ready to proceed. Madam State, you want to call your next witness, please?
Yes, Your Honor. The state calls Tara Helsel.
Good morning.
Good morning.
How are you?
Good, how are you?
You raise your right hand this morning.
Do you solemnly swear or affirm the testimony you should give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Tara Helsel.
Please spell your first and last name for the court reporter.
Tarah, last name Helsel.
Thank you.
Please have a seat. Elsa, the microphone in front of you moves up or down, doesn't go back and forth.
Okay.
Ready?
Yep.
Counsel, you may proceed.
Thank you. Good morning.
Good morning.
Can you introduce yourself to the jury and tell them where you're currently employed?
Yes, my name is Tara Helsel, and I work at RJ Lee Group.
And in what capacity do you work at that group?
I am a forensic scientist and the manager of the forensics department
How long have you been employed by RG?
since November of 2016.
Can you give the jury a background into your education?
Yes, I have a Bachelor of Science degree in forensic science from Waynesburg University.
And how about some of your training and certifications?
Sure. So I had to complete RJ Lee Group's training program for gunshot residue analysis. And this was a several month-long process that involved reading and learning the standard operating procedures, reading relevant publications about gunshot residue. I had to complete the analysis of 250 case samples, of which my results were compared to that of a trained analyst. I had to receive training on the scanning electron microscope, which is the instrument that we use for our analysis. I also had to take a test about that instrument, a test about gunshot residue overall, and then following all of that, I also had to take a competency exam.
Okay. And can you tell us, you mentioned that you also supervise?
Yes, I'm the manager of the department as well.
So how many individuals do you supervise?
Right now, just one.
And so you're responsible for their overseeing their work as well?
Yes, absolutely.
And how many times have you ever testified in court regarding the area of GSR?
84 previous times.
And in the state of Florida
Yes, I believe 13 of those were in Florida.
and other states as well?
Yes, I've testified in 20 different states, as well as Puerto Rico, Bermuda, and Turks and Caicos.
Has your entire professional career in the area of GSR been with RJ Lee?
Yes, it has been.
Okay. Can you explain to the jury what is gunshot residue, commonly referred to as GSR?
Yes, so gunshot residue in the broadest sense of the term is referring to all of the particles that result from the discharging of a firearm. However, when I am talking about gunshot residue, I am referring specifically to the particles that come from the primer, which is one of the parts of the cartridge.
Okay. And what is the primer? And you can give us kind of a summary because you did hear from an expert yesterday regarding it.
Sure. So when you're thinking about a cartridge, it has the projectile or the bullet in it. It has gunpowder. And then at the bottom of the cartridge is something called the primer cap. And inside of there is a mixture called the primer. And that contains a couple of different compounds that together contain the metals of lead, barium, and antimony.
So lead, barium, and antimony.
Yes.
Okay, we'll remember those three. So how is it that gunshot residue is produced and deposited in a manner in which you then analyze?
So whenever a firearm is discharged and the trigger is pulled, this causes something inside of the firearm called the firing pin to strike the primer cap. So it'll hit the bottom of that cartridge and this will start a reaction. So this will cause the primer to burn, and the burning of the primer causes the gunpowder to burn. So as the gunpowder burns, there is a buildup of high heat and, as a result, high pressure inside of the firearm. And that buildup of pressure is what ultimately will expel the bullet from the firearm. But because of that buildup of heat, those different elements I mentioned, such as the lead, barium, and antimony, are also going to heat up and become a gas. And this gas will exit the firearm through any available openings in the form of a vaporous cloud called a plume. So you have this gas exit the firearm, and it's now much cooler outside of the firearm than it was inside of the firearm. So those different metals will cool down and combine together and form particles, and those particles will land on the area surrounding the discharge, and those are the particles that I am looking for in my analysis.
And in general, how far is that gas traveling?
It depends on the environmental conditions. Things like weather and airflow can play a role, but in static conditions, typically about 4 to 6 feet.
Okay, and you mentioned the particles. What are the particles that are being produced by the discharge that you're looking for?
So there are 3 different types of primer-related particles. So the first are called particles characteristic of gunshot residue. And these would be particles that have lead, barium, and antimony all together in one particle. So these are considered characteristic because there are very few other sources of these particles aside from the discharge of a firearm, and it is the presence of those that we need to have to be able to call a sample positive for gunshot residue. There are also what are called 2-component particles, which would be any particle that contains 2 of those 3 metals. So it could be lead and barium, or lead and antimony, or barium and antimony. And these 2-component particles also can come from the discharge of a firearm, but there are other sources of them. So when they're found by themselves, they're not as conclusive to the presence of gunshot residue because they could have come from something else. But if they're found in combination with particles characteristic of gunshot residue, they're more likely to be from the discharge of a firearm and are kind of acting as part of that GSR population. And there is a third type of particle, which is just a 1-component particle, which would be lead by itself, barium by itself, or antimony by itself. And these also come from the discharge of a firearm, but there are even more other sources of those particles to where they're not very conclusive to the presence of gunshot residue, so we at our Lee group do not report on those. We are just reporting on the characteristic particles and the 2-component particles.
And that's because, for instance, lead can be found in paint.
Yes, absolutely.
So the presence of lead in and of itself isn't indicative of GSR.
Exactly.
And can you describe for us how you perform the analysis? And I know you brought up the microscope, which was briefly mentioned yesterday. Can you describe for us how that microscope works and your process?
Yes. So we use an instrument called the scanning electron microscope, which is also referred to as the SEM for short. So this is a very powerful microscope, and it is computer controlled. So instead of looking at your samples through an eyepiece like you would in a traditional microscope, you're actually looking at them on a computer screen. And this instrument has the ability to magnify by thousands of times. And it also allows you to see the chemical composition of what you are looking at. So because gunshot residue is extremely small and not visible to the naked eye, and is made of very specific elements, that's why we use the SEM. And the way our analysis actually works with it is 2 parts. So the first part is an automated analysis. So I will take the samples and put them into the microscope, and I will set up parameters on the computer telling it, here are the samples I have, here's where they are located on my sample folder. From there, the computer will scan the surface of those samples, looking for potential gunshot residue related particles. If it comes across something that it thinks could be gunshot residue, it will stop and take a picture of that particle and also save the coordinates for where it is located on that sample. So it will finish going through and scanning all of the samples, and after that, I will do the second part of our analysis, which is the manual analysis. So I will go back to those particles that the instrument flagged, and I will examine them. So I will look at their shape, and I'll see if that's consistent with gunshot residue, which would be something that is smooth or round in shape as the result of a high heat reaction. In addition to that, I will look at the chemical composition of those particles and make the determination for what type of particle it is that I am looking at.
And the automated process is performed by the SEM, right, the SEM for short?
Yes.
And what is it looking for? Those particles that we discussed earlier, or the compounds, the barium?
Yes. So basically, the way the SEM works is kind of based on brightness. So the more dense something is, the brighter it will appear. Because lead, barium, and antimony are heavy metals, gunshot residue-related particles will appear very bright. So it's scanning the samples based on brightness. And if it finds something above a certain brightness, that's when it will stop and collect a spectrum to determine what elements are in there. If there's lead, barium, or antimony, or any combination of those, that's when it will save where it's located and take a picture of that particle.
And would a demonstrative aid assist you in your testimony to the jury as far as what the SEM shows?
Yes.
Again, ladies and gentlemen, the witness is going to be using a visual or demonstrative aid to assist in explaining or illustrating her testimony. Just remember that the testimony of the witness is the evidence. However, this demonstrative aid is not to be considered value as evidence in the case unless it's later received in evidence, and you should not use it as a substitute for evidence. Only items that are actually in evidence will go back with you to the jury room during your deliberations. You may proceed, counsel.
Thank you. And without getting into the actual results, we're just going to orient the jury to the chart that I have here, beginning with the top left.
Yes, so the top left is an image kind of showing where the particle is located on the sample, and that is taken at 400 times magnification.
And the top right?
That is now a closer up image of that particle taken at 3200 times magnification, where you can see clearly that it is bright, it is round in shape, and you kind of are able to visualize really the morphology of that particle.
And bottom left?
So that is what is called the EDS spectrum. Basically, it's just showing you what elements are present in that particle. So PB is lead, BA is barium, and SB is antimony. So you see peaks for all of those present in that particle. Therefore, it is a particle that contains lead, barium, and antimony, which makes it characteristic of gunshot residue.
And are the peaks that we see consistent with the amount of that compound within the sample?
Yes, overall, the height of the peaks relate to how much of that element is in the particle.
And finally, the bottom right.
So that is the image that the instrument takes during the automated analysis.
And did you receive a sample in this particular case for analysis?
Yes, I did.
Your Honor, urging defense counsel has been previously marked as states LLL for identification purposes. Your Honor, permission to approach the witness?
You may.
And if you need to handle anything biological, there are gloves right there, and the top has been open for ease of access. Tell me if you recognize it first, and if you need to open it. If you can just keep it outside the view of the jury.
I do recognize it.
And how is it that you recognize it?
This is one of the items that I received in this particular case.
And it was one sample, and what did that sample contain?
It contained a collection stub labeled as coming from the inside of a Jeep.
Okay, and is that in the same or substantially the same condition as the last time you saw it?
Yes.
Your Honor, at this time, the state would use into evidence which is pre-marked as states LLL as the next numbered exhibit.
No, Judge.
Thank you. It'll be admitted. What's the next number?
60.
60 in evidence. Thank you.
I know, it's almost 10 o'clock. Where you at now?
Looking for 57. I'm showing you what's been entered into evidence that states 57. Do you recognize that?
I do, yes.
And what is that?
This is a gunshot residue kit that we received in this case.
Okay. And did you analyze states 57?
Yes, I did.
And did you ultimately analyze state 60?
Yes, I did.
Okay. So, let me grab your scissors. Go ahead and open states 57. And I'm going to ask permission from the judge for you to step down.
You may.
You want to open it, grab some gloves, and we'll
Okay.
go to the machine.
Just if you can publish states 57.
And the contents. So you received one sample, but there are 2 tubes.
Yes.
What are they representative of?
These were samples that we had received that are labeled as coming from the right hand and the left hand.
And who's the individual?
Cortland Henry.
And you can put those back in. And if you can publish states 60. And we have 1 tube, and what is that representative of?
It is labeled as coming from inside of a Jeep.
If you believe it, it will adjust. Thank you. You can put it back in and keep your seat. Okay, we're going to start with case 57. Did you ultimately have a chance to analyze and go through this SEM process, which is the automated process, and your individual process, in order to come up with an opinion as to the presence of GSO?
Yes.
And what was that opinion? And if you can specify both the left and then the right.
So the right hand of Cortland Henry contained 0 particles characteristic of gunshot residue and 2 two-component particles. And the left hand contained 1 particle characteristic of gunshot residue and 1 two-component particle.
Okay. And can you explain to us what that means?
Basically, overall, there was gunshot residue present on the hands.
Okay. And what affects the presence or absence of GSR on a person's hand or any object?
Sure. So if there is gunshot residue on someone's hands, that means that the individual got it on themselves by either discharging a firearm, being in the proximity of a firearm when it was discharged, or by coming into contact with a surface or object with gunshot residue on it.
And if we may go back to the demonstrative aid, what was this demonstrative aid? Was this representative of your results with Portland Henry?
Yes, that was the particle characteristic of gunshot residue that was on the left hand.
And the components, which you explained before, there are three kinds or three compounds that you were looking for, and which compounds were present in Portland Henry's left hand.
Lead, barium, and antimony were present in that particle.
So all three components.
Yes.
Okay, and let's move on to stage 60, which was the sample for the Jeep. What were your results? And again, did you also go through the SEM automated process and then your individual characteristic process?
I did, yes. So there were
You
0
got it.
particles characteristic of gunshot residue,
Huh?
but at least 9 two-component particles.
Okay. And what does that mean?
So, like I mentioned, two-component particles can come from gunshot residue, but they also
I
have
think
other
it's different.
sources. So, because of that, these results are basically inconclusive. They could be gunshot residue, but they also could be from something else, and I can't say which it is.
Okay. In your analysis and reviewing the sample, did you find anything inconsistent with gunshot residue, if I'm phrasing that correctly?
Correct, and I did not. So overall, with two-component particles, or any of the particles we look at, oftentimes if the particles are from another source, there are other elements or amounts of elements that would be unusual to find in gunshot residue. So, for example, one common source of two-component particles is brake pads. Brake pads typically contain high amounts of the element iron. So if I'm doing my analysis and I come across particles with high amounts of iron, I eliminate them and I do not report them because there's something about them that would suggest they're from something else. So while I still cannot call these particles gunshot residue, there was nothing about those particles that were unusual.
Okay. And I want to ask you about presumptive tests. Are you familiar with them in general?
I am, yes.
Are you familiar with the friend or foe presumptive GSR kit?
I am.
What is that kit testing?
That kit is like you said, a presumptive test that is looking for the presence of nitrates, so nitrogen-containing compounds.
Okay. So, for instance, these GSR kits are made to essentially alert to the presence of a certain compound.
Yes.
And the friend or foe kit specifically alerts to the compound of nitrogen particles.
Yes.
So the presence or absence of nitrogen particles.
Correct.
And are presumptive tests relied on exclusively?
No, they are just a screening tool. Like I mentioned, they're looking for nitrates, and there are many things that can contain nitrates. So they are not conclusive to the presence of gunshot residue or gunpowder. They are really just to be used as a screening tool.
Your Honor, moment to confer?
Yes.
Nothing further.
Councilor Zane Cross,
Yes,
you're ready to proceed.
thank you. Good morning.
Good morning.
I don't think we've had an opportunity to meet.
No.
You got the sample from Miramar Police Department,
Yes.
specifically Detective Moretti directed it to you.
Yes.
And when we talk about GSR, or gunshot residue, you're aware that GSR can be found on clothes, right?
Yes, that's possible.
Did Detective Moretti send you any clothes of Cortland Henry?
He did not.
He didn't send you any of the clothes?
No.
Did you know that the clothes of Cortland Henry were collected by the Miramar Police Department?
Objection, calls for speculation outside the scope of court.
Well, I don't know that calls for speculation. If she knows she can answer the question, overruled.
Were you aware that the Miramar Police Department collected Cortland Henry's clothes?
No, I was not aware of that.
But if, in your examination, had you received clothes, you could test those clothes for GSR, correct?
Yes, we can
And you-
certainly test clothing.
And you've done that many times, correct?
Yes, absolutely.
Also, if someone is in a hospital, in a bed in a hospital, do you know if that person has washed their hands?
I don't.
Okay. And by washing your hands, you can get rid of GSR, correct?
Yes, hand washing can remove most, if not all, of the particles on someone's hands.
Do you know if Cortland Henry washed his hands or changed his clothes?
I don't know that.
Could I have one moment?
Yes, sir.
Thank you very much.
Thank you.
Any redirect?
Yes, Your Honor. Is hand washing the only thing, contrary to popular belief, that removes gunshot residue?
No, gunshot residue is easily removed in general. So with respect to the hands, any type of activity, touching or use of the hands can remove particles pretty easily. With clothing, any activity. So if the garment is touching things, if it's laundered,
If it's removed,
yes, any activity can cause particles to be disrupted or removed.
and you're an independent lab, correct?
Yes, we are.
You're not associated with Miramar Police Department.
Correct, we are not.
You're not associated with the Broward Sheriff's Office.
We are not.
So you can only test what you're submitted, correct?
Correct.
Nothing further.
One question, if I
Yes.
may. You were hired by the Miramar Police Department to perform this test then, correct?
Yes, they're the ones that submitted the samples.
Thank you.
Anything else?
No, Your Honor, nothing further.
Is this witness excused?
Yes, Your Honor.
Thank you very much, ma'am. Can you step down, you're excused? Thank you. Can I see sidewalk, please? Ladies and gentlemen, I need a few minutes with the lawyers. Please do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in the presence and search for no research. Thank you. Just leave your notepads on the chair. I let the record reflect the juror stepped down, counsel remained, along with the defendant and the assistant state attorneys. So I have, and this has been marked as states JJJ, triple J, and it's a Snapchat account. And so what does this purport to be?
That is the business record production from Snap Incorporated, which is the business that runs the social media app of Snapchat. The records are the records of Mr. Defendant Janelle Demmons. They are conversations and statements that he makes, some of which reference this homicide and Cortland Henry. And there's in specific comments from Mr. Demmons to an individual that's identified by a Snapchat name and it's on there, DHAT is what it starts with, in which he says that Cortland Henry did something very important for him. I'm paraphrasing from the language on that. In terms of establishing that those records belong to the defendant, the state has to prove that beyond a reasonable doubt to the jurors. So that is why it's necessary to show that all of the photos and videos in that particular item are of Jamel Devins. In addition, the person that he is speaking to, the one that starts with DHAT, that individual, there are images of her that are transferred back and forth. So that is identified as Mariah Hamilton. That is the defendant's girlfriend at the time. She's also in some of the videos. And then there are videos that the defendant sends to her that in which he indicates you shouldn't be speaking on me, basically discouraging her from speaking with law enforcement.
So regarding these videos, how long are they? How many? I mean, you sent me a
Yes, that's
3
the,
pages listed. I don't know how long these take to take a look at.
they're less than 30 seconds each approximately.
So let's
Sure.
put them in.
The drive that is right there in here.
Or just handle that.
Well, yeah, that's fine now. Just has to go back. But why don't you sit over there? Is RFP sit over there? Or you? They're good?
I think that might be good.
You can reposition yourself.
Yeah, I wouldn't know.
Thank you. And feel free to do that throughout.
Thank you.
If there's something showing up on the screen and you think you want a better view of it, you're always welcome.
And this is the business records certification as included on the file from Snapchat.
Yeah, I saw those. I'm not talking about that. I'm talking about the actual videos.
So do you want to see the images larger as well, Your Honor?
Yeah, I'd like to know what you're going to show to the jury.
Of
They're
course.
objecting to it, saying it's not relevant. I don't believe there's an objection that's not authentic, that it's, not his account from Snapchat. I understand that. If that's the case, but my understanding is they're saying it's not relevant.
This is the one that I indicated would potentially have the items that defense didn't want in, such as the names of the songs of the defendant.
We don't have to concern ourselves about that. The state agreed to get that out. So,
Image of the defendant, an image of the defendant and Mariah Hamilton, image of the defendant,
Now, you're saying that this is the defendant and Mariah Hamilton, and I haven't heard anybody identify her yet. Is that, who's
correct?
gonna
That's
do
why
that?
the next witness would do that.
Oh, okay, so the witness is going to do that.
Yes, Your Honor. There she is again. That is Ms. Hamilton. This is the Snapchat logo of the defendant. Moving on to the videos. This video here is before the homicide. It includes the defendant and one of the victims, Christopher Thomas. There is volume to it. I don't know if the TV is turned down.
Gary, can you check on that?
that's good.
That's 63 or 62. There is a volume.
tried VLC.
That was VLC, so.
Oh.
Yeah, I think that one. Sharon, I'll switch over to a different computer. Sorry.
This bitch look like he got 5 kids at the student pickup right now, waiting.
Your Honor, for the interest of time, should the state be proffering the relevance of each video as we go?
No, thank you. I'd just like to see it and see what,
Right.
my understanding. Well, go ahead.
Okay.
Right. All right, thanks for shaking. Maybe the most important shaking. The most important shaking. Thank you. your record on that. You know you come back. You be someone pick up on me. Hey man, I'm 19, I done seen 750,000 each. I ordered it, it'll be a meal. Got me sure. It'll be a meal, I make sure. You put sad when you get out, man. Dude, put sad when you get off y'all ass, man. Get off y'all ass, man. Hey bro, don't be speaking on you, bro. You ain't do that. You ain't do that. I bet not about your ass saying you did that.
Those all the videos, Counsel?
Yes, Your Honor.
All right, so, Counsel, why don't you tell me your complete objection so I fully understand what you're objecting to on the videos as well as the remaining portion of this Snapchat under, I think it's AAA.
Your Honor, our first objection would be relevance. I think Florida statute 9401 defines relevance as evidence tending to prove or disprove a material fact. There was not a single video that you witnessed there that implicates in any way any fact and issue in this case. I want the court to be aware of what a Snapchat account is versus a video off of a phone. They're two different things. You can access that Snapchat account from your computer that's right before you. So a Snapchat account or any social media account is not particular to a device. This is contents from an account that exists in the cloud or on the platform of Snapchat and is not peculiar to a particular device. So it doesn't identify a device. It identifies a social media account. The notion that anything a defendant says can and will be used against him is an issue of hearsay. It's not a relevancy issue. None of those videos I haven't heard, and I think that probably we're putting cart before the horse by making me object to the relevance before she advances her theory of relevance. But the fact is, unless I'm missing something, there is nothing there that concerns the events of October the 26th, 2018 in any way. As far as the messages are concerned, it's similar.
Now we're talking about what's in writing, correct?
What's in writing is essentially a dump from that account, a selective dump, I think from August the 3rd through some date in November. If the state is indicating that there are messages there that relate to the offense, then the state should isolate those messages and make its argument as to what the relevance of those statements is or are. But to suggest that you can just dump all statements that somebody makes since birth until the time of their trial, and because it's non-hearsay because it's a statement of the defendant. And by the way, these are exchanges, so a relevancy objection, or sorry, a hearsay objection relates to the statements of the defendant, not the ones that are made back to him in any kind of conversational exchange. Those statements themselves are hearsay because they aren't statements of the defendant. And now, and I'm making this argument assuming, because I'm dealing with relevancy, assuming that those statements are indeed statements of the defendant, which I'm not conceding. They have to have some relevance to this trial and facts in issue at this trial. There are some statements that I observed that seem to be some maybe terse or conversations between him and any person that might cast him in a poor light because of the manner in which he communicates. How is that relevant to this case? So relevance is number one. A statement has to be relevant. So each statement the state would have to establish the relevance of each statement in isolation prior to it being admitted into evidence. Saying these are all from his phone and therefore they're all his statements and this is a business record exception and therefore they get in doesn't cut it. As far as authenticity is concerned, and that's our relevance objection. Relevance must be established. I'll cite the court authenticity issues or authentication issues concern Rule Florida Statute 9.901. And I'll cite the court to some case law that doesn't necessarily deal with social media, it deals with text messages and emails. Simonet. I can't remember if it's Simonet v. State or State versus Simonet, but it's 100 Southern 3rd 180, which stands for concerns text on a cell phone. And it indicates, these are some notes that I took down because I didn't realize she was going to be trying to bring this in today. We had asked for some indication as to the witnesses, and I think this is the only day we didn't get any indication, and so there's an element of ambush. But nonetheless, in the Simonet case, it stands for some legal principles that were articulated in that holding that I took note of. One, in that case, there was concern regarding the admission of screenshots of text messages, communications. And the court said it was okay because there was a witness that testified that she was sitting next to the defendant in a car when the texts were made. And the detective recovered a cell phone from the defendant, and the witness identified the text messages between her and the defendant. In other words, there was a party to the communication who was able to authenticate the communication and who the participants are. Another case is Roy, which is 279 Southern 3rd 238.
279 what?
Southern 3rd 238, which concerns emails and texts. And these were emails that were admitted through the investigator that was posing as a 14-year-old in what appears to be a case that concerns some sort of a pedophile sting. And the investigator involved in the exchange, the investigator was involved in the exchange in the emails of the text. One of the quotes that I took from that case says, most common way to identify social media, which would be this, and things akin to social media, is to let the author testify that they're the ones who generated or created it. So there's somebody that is involved in the exchange of the communication that can attest to the fact that they created it or were involved in it and identify the parties that were involved in the exchange. When a participant is used to authenticate electronic exchange, the focus is on the witness's ability to identify the person against whom the communication is offered. In criminal cases, the person communicating with the target of the investigation must be able to identify the target through some personal knowledge or experience. So this establishes that there has to be somebody who participated in the communication, who authenticates the participants in the exchange, and must be able to identify the participants in the exchange. In the Roy case, the sergeant, who was posing as a 14-year-old, acknowledged that he had no idea who was on the other side of the emails and texts. Here we have nobody at all, let alone somebody whose knowledge is insufficient.
This is just a PC affirm case. These opinions are, right? Am I reading this right? This is a PC affirm. That's in the concurring opinions or?
The Roy versus State. I can print it out if you don't.
I'm reading it right now.
I'm not sure that what the court is.
It's a PCA affirm.
Meaning the language that I'm reading doesn't exist?
It exists. I'm sure it's there. I didn't read the whole concurrence. It's
Okay,
there, but it's a PCA affirm.
Well, maybe I cited it incorrectly.
No, you cited it right. 279, Southern 3rd, 238. All right, go ahead.
Okay, this is language I took from the cases themselves.
I don't doubt it.
Okay.
Seems like it's all here.
Okay. I'm not sure the significance of a PCA affirm meaning.
That's not the opinion of the court. It's the opinion of one judge. That's what his concurrence was, his or her opinion, and there's another judge has a different concurring opinion. There's no specific majority opinion. I don't see one. The other concurring opinion says he'd reverse, but it's a PCA affirm.
I'm not quite sure of the significance of that, but I'm sure the court has a message it's communicating. No evidence that the texts were recovered from a phone, A, belonging to, in the possession of, the appellant pursuant to a search warrant, is another quote. Further, in that case, the sergeant could not identify appellant as a person on the side of the emails or on the other side of the emails or texts. Lamb versus State, 246 Southern 2nd 400, a 4th DCA case in 2018. A quote that I took from that says, a case involving authentication of a Facebook video, or videos here, is also instructive. In that case, the 4th District recognized a distinction between authentication of a video recording and an audio recording. An audio recording would be more akin to a communication that you can't tell the identity of the communicator's visual. The 4th District acknowledged its prior holding that authentication of an audio recording, quote, should be made by the technician who operated the recording device or a person with knowledge of the conversation that was recorded. Quoting Santana versus State 191 Southern 3rd 946, which is another 4th District case. So as far as authentication is concerned, Your Honor, and the PCA affirmed component, notwithstanding, the articulation that is being made repeatedly by district courts of Florida, of this state, and by the 4th District, are that when you are introducing text messages, communications that are in print, audio, somebody has to identify the participants. You can't just put them in and say, this is the guy who said it. You have to lay a predicate of authentication, which the state is not attempting to do. So as far as relevance is concerned, they have to establish relevance of each statement. They can't just say, here are all the communications he ever made, and notwithstanding who he's making them with, whose statements are themselves hearsay, because his statements are statements of the defendant and therefore not hearsay, non-hearsay by definition, they come in, they have to establish the relevance. So we object. One second. So the communications are not particular to a phone, so it doesn't meet that hurdle. They are particular to a social media platform. A social media platform that they have to establish belongs to the defendant, and I don't think they have said how they purport to do that. Even if they do that, the statements of anybody else in those exchanges is hearsay. Statements of the defendant are irrelevant, and the photographs and videos are also irrelevant and prejudicial pursuant to 90.403.
Thank you, and I misspoke. There was one opinion, it's a PC affirmed on Benjamin v. State, or Benjamin D. Roy v. State, that you cited, 279 Southern 3rd, 238. It's a PC affirmed, there is a concurrence, and he would concur in part and would reverse in part. I misspoke. All right, so yes, counsel, you want to be heard?
Yes, Your Honor. With regards to, and defense counsel already has the Lamb case, so I'll just provide a printed copy to Your Honor. Specifically, authentication for the purpose of admission is a relatively low threshold that only requires a prima facie showing that the proper evidence is authentic. I'm reading on the 9th page of notes 5 and 6. Your Honor. Lamb case goes on to state that authentication for the purpose of admission is the ultimate determination of authenticity of the evidence. Is a question for the fact finder. Evidence may be authenticated by appearance, content, substance, internal patterns, or other distinctive characteristics taken in conjunction with the circumstances. In addition, the evidence may be authenticated either by using extrinsic evidence or by showing that it meets the requirements for self-authentication. With regards to the evidence that's before Your Honor, the defense is not agreeing that it's his account. So then the burden is on the state to prove that it's his account. As such, the evidence itself shows that it's authentic, as it is the defendant in every single one of those videos. In terms of the contents of the defendant's statements, they are relevant. They go to the issue and fact of whether or not he committed these two homicides. The contents of the questions are important for giving context. An answer without any context doesn't give the fact finder, the jury, any way to meaningfully evaluate the statements. So based on the standard, which is low for authentication, the state has done that by the business record certification and the fact that the email address and everything else will be linked up in other witnesses as well, showing that that was the defendant's particular iCloud account that is the username. It's also important to note, Your Honor, that while the individual doesn't tie it to a specific device, it ties it to a specific individual because it's a unique logon and username and password, just like an email account, that it was used by this defendant.
Thank you. Anything else, counsel?
Yes, Your Honor. There are statements there that, in the conversations, that started on October 3rd. October 3rd, this incident occurred on the 26th. The state is making a blanket assertion that these statements go to demonstrate his complicity in these homicides. Each statement has to be identified and the argument has to be made as to each such statement by itself so the court can have a way of evaluating the purported relevance. They can't just say they're relevant to the homicide. That is insufficient. And if they do not identify each particular statement and the relevance of each particular statement, then dumping them all in on some blanket assertion that they're relevant would be error, and it would invite error, and it would prejudice Mr. Demons irreparably. So, context for what? He's having a discussion with somebody on October 3rd, if they're saying that that constitutes some plan that establishes premeditation, then let them advance that argument. They have not referenced a single one of those conversations with specificity and advanced some argument that ties it to a fact and issue in this case. So I would say that on the relevance alone, the state fails to make a showing that would allow the court to even properly analyze the question and issue.
Thank you. I'm going to defer ruling out, take a look at your cases that you just sent. We're going to take a short recess. Mr. Demings, you need a restroom break? Yes? Can you arrange for a restroom break? We'll be in recess. Thank you. Assistant State Attorneys, jurors in the jury room. Counsel, I've had an opportunity to take a look at your cases and read over a little bit more about Snapchat. And my thought is this: I understand the defense objection, I'd be admitting it, allowing the evidence to come in. However, there's a couple caveats. Number one is, one of the videos I saw has a gun in it. This is all.
Shows access to the murder of firearm 6 days before the homicide.
Right. I don't see how that is relevant to anything, and I think it's more prejudicial and probative, and it shouldn't be there. All right? So I'm not allowing that weapon in. It's not like you had something 15 minutes or a half hour before the incident in question. I'm not letting something in with a gun days before. That's number one. Number two, I know there's been no argument that 403 analysis, but I don't see how any of the pictures and the videos with all the flash and the cash and all that really has anything to do with anything. I want all those out. I'm not admitting those. All right?
So the videos of him in the bathroom with the stack of cash.
Anything where he's flashing all the cash, I don't see how any of those things are relevant. They're more prejudicial and probative. The gun is more prejudicial and probative. I'm not letting it.
Okay, so what I'll do, with your next permission, is I will pull them up here and verify them. Because then I would be changing the business records on that. So, but that's important with your honors roll. So that would be these 3 videos in the bathroom. Judge, with regards to this particular video, the second video doesn't have the defendant's picture in it, so just so it's clear. So and so what I would suggest is that I can modify that video to take out the part where the gun is there, and then, so it would just go from there and then excise the portion where the gun is shown, because that is showing who is speaking and showing who is then showing the driver's license.
It's fine. The gun should be out. It's not.
Your Honor,
It's staged before.
could she at least articulate the relevance of anything? I mean, I understand.
I heard your argument. I understand it.
Okay.
And I've overruled it.
It is overruled.
Overruled. The only thing I'm doing is on 403 analysis, saying that you can't. I don't see the relevance. I don't see the probative value of the gun and the cash being outweighed by overruled.
Defense counsel is also asking to take out the photo of the song and their titles or whichever else.
Right, I agree. Take it out. Murder on my mind.
I just need about 5 minutes to fix that video.
All right, we'll be in recess. You work on it.
Thank you.
Yes, sir, you want to say something?
Yes, Your Honor. So has the court articulated its ruling concerning the visual images, the videos and pictures, or has the court also decided that all the communications come in without the state asserting a relevancy objection as to each state, or a relevancy as to each state?
Counsel, the videos, my understanding, the videos as well as the written conversations are you articulated and objected, saying they're not relevant and they can't be authenticated and things like that, and the objection is they can't be authenticated. We don't, because how Snapchat works, anybody could have done it. And counsel's suggesting to me that she needs to put it in to show that it's his, because he's the one that's picture on those accounts. It's authenticating. I know I'm the determination of what's authentic, whether it's authentic or not. I'm making that decision. But it appears to me it's going to be argued that it's not his account, or he's not the one that's putting this information on there. That's the tenor of what you're suggesting. So it just seems to me that goes to show who's on the account and whose account it is.
No, I understand that, Your Honor, and please do not understand me to be arguing a decision that the court has made. I'm trying to understand that saying that we're going to put all this in to prove, we're going to put in all these conversations to prove that it's his Snapchat account. Why are they trying to prove that it's his Snapchat account if not to get the very statements in? So if the statements themselves are relevant, saying, well, we're going to put in these statements to prove it's his Snapchat account, should they at least articulate why are you trying to prove that it's his Snapchat account?
This is a statement in there which there's the state believes is an admission.
Okay, well, if that is the case, then that statement should come in, and if those statements are isolated, then the defense would be in a position to determine whether or not they're going to take the position that it is not his Snapchat account and do a 403 analysis of our own. So if they're saying there are 3 statements in there that constitute admissions, fine. If they might want to put those in, and we might say, okay, we're not going to contest that it's his account, so you don't have to put in all the other stuff that is prejudicial. But they have to at least articulate it and isolate it so that we can make an informed decision.
Thank you, counsel. You didn't bring up the fact that there's it's overly prejudicial. You had a straight relevance objection and authentication objection. I've overruled those objections. When I looked at the video, I said, nobody else, I said, I think that's too prejudicial, not probative of anything, the picture of him with a gun, and I want it out of there. I said the same thing regarding the cash. You did tell me, and I didn't articulate it, that you were concerned about the video with murder on my mind, and I agree with that. That should be out as well. All right? Okay. So that's the ruling. It's the relevance objection's overruled. The authentication objection, I'd admit it, but I don't want the items that I previously discussed being shown to the jury.
Thank you.
Here, if I may have a moment to show defense counsel the clip as it's been
You go ahead.
edited.
We're in recess for a minute.
Thank you.
Show whatever you want to show.
All the other ones are already taken out. This is the other one to take out the gun.
It's a date of these so-called videos on.
Yes, they are on each specific one.
Could I see that diagram again?
Yes, it's there.
May I have a moment to see what to say?
Yes?
Come on over here for a second.
We're in recess.
The purpose of this is Snapchat account.
Snapchat.
Can you at least identify what you think is a confession in there? Identify it, but I don't understand why you would not identify it, because then you might not make an objection to the rest.
But you probably still want to that.
Yeah, but then it would be invisible based on her theory. judge said take him out, take him out. If you take him out, don't take him out, then. I don't need to say.
And anything else that's ever mentioned besides this? No.
No, I would take the position that if you think there are confessions in there or statements that implicate him, identify them. This is the only one.
Dispatch. On November 9th.
No.
On November
You're
9th.
telling me what I'm saying. I'm saying identify what you want in. Because you think it's all admissible to prove that it's his account. If we're not contesting that it's his account, then you're putting in an informed information. Identify what you want in so that we can make an informed decision. If you violate the judge's order, then it's a you problem. I don't need to review it.
I know you gave it to him. Not to speak.
Yes.
Okay. I'm not trying to be difficult. I know you have problems with
Council's going to take you a few minutes.
The video is
Yes, we
done.
need a few minutes. I think Mr. Allison is taking a pizza.
And we just wanted to be clear that if we
We're in
are,
recess now, so you want to be on the record again?
yes, just so I can complete the record on this one point.
Let the record reflect the presence of the defendant, his counsel, the assistant state attorney, jurors, and juror. Yes, sir?
The state is asserting that among the conversations in state's exhibit, what was it, mark for identification?
Jay?
Triple J.
Triple J, that there are certain conversations or certain exchanges which she believes relate to facts and issue, and that the rest of them she is using to authenticate or to establish that it is the account of Mr. Demons. I'm just putting on the record that the defense would be willing, if she does isolate those conversations, to consider not objecting or not making the claim that it's not his account, so that she can get in whatever she deems is relevant, and we can avoid the prejudice of the remaining contents that she intends to put in that is not relevant, and she only intends to put in to establish that it's his account. I just wanted it to be clear that that is an offer that we have tendered to the state, and we're articulating for the court. Thank you.
Thank you. What says the state?
Your Honor, the state is going forward that the state has to convince the jury beyond a reasonable doubt as to the authenticity and who those messages link to. And that was the way defense counsel indicated from the beginning that that is how the state needed to proceed. So at this point, the state would enter the evidence as it is currently put.
Thank you. Can I see you, please? Because there's whole conversations with Ms. Mariah Hamilton that really, that goes to authenticate the whose account it is, but I don't know that it does anything other than that. And can I see the the exchange again, please? JJJ.
Oh, I left it right there, I'm sorry.
And Mr. Edelstein asked me to print another copy for him, so I'm trying to work on that.
I'm sorry,
I
Your Honor.
apologize.
No, it's my fault, I accept the responsibility. Federal court, I get two or 3 points off my guidelines.
So let's get back on record. Again, let the record reflect the presence of the defendant, his counsel, and the assistant state attorney, jury in the jury room. I'm not fully understanding everything that you're saying, Mr. Howard. You're telling me that you're not objecting to the Snapchat conversations. You're not going to argue to the jury in some way, shape, or form that it's not him if it's limited to what the state is suggesting, so the conversations between he and his girlfriend and things like that wouldn't come in. Is that what you're saying?
I am saying, Your Honor, that if we need to be able to make an informed decision. So I'm saying that we need to know what she deems to be relevant, and then when we know that, then we can make the decision that, okay, well, we think that it makes more sense to not make the argument that it might not be his account.
Okay.
So that she can get her evidence in, but to get the rest in. Your Honor.
No problem. We'll just leave it the way it is.
Okay. There may be another issue, not as though you don't have enough on your plate here. We have reason to believe that the state intends to call Miss Felicia Holmes in this next session. And there is the law in this jurisdiction and in this state is that a witness shall not be called merely to be impeached. I don't know that that is the case or not, but I'm concerned with trying to unring a bell. The theory is essentially a statement that the state knows that they will not be able to elicit, and they seek to only impeach their own witness by a prior inconsistent statement, amounts to hearsay because it's being offered for the truth of the matter asserted. So when the state calls a witness that they know is about to, and these are instances when a witness says A and then recants and says B, and the state wants to get A in and knows that the witness's current position is B. To put the witness up there to say B and then impeach them with A is improper. I have here some cases, a few, for the court, stand for that position. Dudley v. State, 545 Southern 2nd, 857, Florida Supreme Court, 1989. Felton v. State, 120 Southern 3rd, 126, Florida 4th UCA, 2013. Curtis v. State, 876 Southern 2nd, 13, Southern 2nd, 13, and that's 1st DCA, 2004, and there are many others. And may I hand up? I have highlighted copies of the cases.
You have them for a state as well?
I do indeed. If I may.
Take a look, whatever you have.
Thank you, sir. Now, I understand that this might be a little bit premature to the extent that I don't know for what purpose they seek to call Ms. Hamilton, but I don't want to be in a situation where we're trying to unring a bell when we are in a position to avoid that prejudice from occurring. So I'm alerting to the court to that possibility, and if that is in any way the state's intention, I would ask that it be voiced now so that the court is in a position to make that assertion. And they don't even need to voice it to us. They can voice it to the court outside our presence.
And who's your next witness?
Felicia Holmes,
All right, so it is Ms. Holmes? And,
not Ms. Hamilton.
Felicia Holmes, sorry.
And what do you anticipate Ms. Holmes saying?
Judge, I believe she'll testify consistently with her previous statement that she gave in 2018. And I'm very familiar with the case law, and I would agree with counsel that the state cannot call a witness just for the purpose of impeachment. However, I'd also direct Your Honor's attention to 90-803 subsection 5, past recollection reported, in which a witness who no longer has a memory of an event but has previously given a memorandum or record as to what happened, they may testify as to lay a predicate as to that, and then that memorandum or record could be read into the record in support thereof.
So are you telling me that you believe that your witness is not going to remember what you said previously?
I believe there are instances in which her memory is no longer available, and that she would testify that she was truthful to law enforcement at the time of the statement in December of 2018, that she now no longer remembers because it has been so long, and that was a time when her memory was better. It was closer in time to the time of the offense. It was within 2 months of the offense occurring and the events of which she witnessed, so that would be admissible under 90-803 sub 5.
So you're telling me you've spoken with her, you know, pre-trial discussion with her, and she said she has no memory of what she said at the time.
There are parts of which the statement she does not recall. That is correct.
May I retort?
Sure.
Okay. A couple of things. One, as with every other witness, the way that you prepare your witness is you refresh their recollection before you call them to the stand. So the notion that this witness is that all the state has been able to glean is that Ms. Holmes no longer recalls something which she said several years ago, and the state has not sought to refresh her recollection, in which case she would have been prepared to testify, then the pretext that she comes in here and says something different and then she impeaches her with a prior consistent statement, claiming that it's an effort to refresh her recollection, is disingenuous and in bad faith. And if that were able to be done, then this body of law would not exist. We also took her deposition, Ms. Holmes, on December 14th of 2022. No, that's not it. Much more recent than that, no?
22. Yeah.
December 2022, in which Ms. Holmes receded from the statements to which the state refers firmly and unequivocally. And the state is therefore, I think the language used in a lot of the cases that I have cited and in a lot of cases on the subject is the state needs to be surprised during the course of its examination at the contents of the statement in order to thereafter impeach their own witness. This notion that, oh yeah, well, she forgot, and while we talked to her, we learned that she forgot, and instead of refreshing her recollection, as we did with every other witness that we put forth prior to in preparation for her testimony, we're going to wait and do it on the stand by impeaching her with a prior inconsistent statement it's a pretext, it's in bad faith, and it's improper. It's prejudicial, and it should not be permitted. Essentially, it amounts to hearsay, because it's a prior inconsistent statement or an out-of-court statement that is going to be used to prove the truth of the matter asserted, which is different from impeachment, where it's not used to prove the matter asserted, it's just introduced to prove that you said something different at a different time. I think these cases are clear. And if that's what they intend to come and do, again, they're inviting error, and I'm alerting the court and the state to it before this miscarriage of justice ensues.
Thank you. Anything else, ma'am?
Just the record's clear in her deposition and counted. She says, I don't remember, or I can't remember, approximately 26 times. The witness has been reviewing her statements and depositions for the past 2 days, and she still persists in saying she does not remember, so that 980305 would be an appropriate remedy to enter the testimony from the prior statement.
By the way, Your Honor, I've highlighted those cases for ease of reference. Or at least two of the three.
And what's her statement, counsel?
What is her statement?
Right.
This was previously provided to defense counsel.
Oh, just give me a synopsis.
Yes,
What is it that you want, or what you believe she's going to testify to, or if she doesn't remember, what you are going to try to refresh her recollection with?
So she says that she was woken up at 4 a.m. Her daughter was screaming. The daughter was on FaceTime with Melly. Mr. Dimmons then says he was saying that Mr. Dimmons was saying that someone just shot the car up and was trying to shoot them. He then said there's like a car coming behind them and he's hiding. So then she asks Mr. Dimmons, "Are you okay?" His response was, "I'm okay." She then asks him where are Sack and Juvie, the common nicknames of the two victims, and he said, "I don't know if they're in the car. I think they're dead." So she then says, you think they're dead. She then goes through and describes her actions and conduct. She said that she called his mother, Jamie. Oh, I wouldn't go into the contents of that conversation because that would be hearsay. She then describes what she sees, which was her daughter on the phone on FaceTime with Mr. Dimmons. She then says that she's going to come down, and then she describes her actions, that she hopped in the car and came down to South Florida. She said that at that point she asked and called Mr. Dimmons again, spoke with him and said I'm at my friend Fredo's house. Fredo picked me up, so we went to Fredo's house. Then she describes that Fredo lives over in the same neighborhood that Melly lives in, and that she went in through another gate from the same neighborhood on that one. She then says shortly thereafter in her statement, when they get to Fredo's house, that Melly comes out and he takes Mariah and they go upstairs at Fredo's house. Then she also goes through and indicates that after this incident, that Mariah, her daughter, Mr. Dimmons, Cortland Henry, and Cortland Henry's girlfriend are living together in a condo in Miami. She's going to testify that she didn't, and the statement also says that she didn't see any blood or anything on his clothes or anything like that. The questions asked then about her being FaceTimed, meaning Mariah Hamilton, the daughter of Felicia Holmes, FaceTimed, and her answer at that point was, he FaceTimed my daughter from the 772 number. So then she continues on, unless he got rid of that phone. He FaceTimed my daughter that morning at 4 in the morning, yeah. Then she's asked, what's her daughter's number? And she gives her daughter's phone number at that time, 321-506-1313. Then it continues on, and so the law enforcement officer asks and says, I have his phone records, meaning that of Mr. Dimmons, and he never called, there was never. Then she identifies the phone number as, you have the 772-713-9807 number. She then continues on, he called and FaceTimed with, I talked to him on FaceTime. Then there's another incident, I don't know if potentially this could be possibly admissible, depending on the testimony. She says that they told me there were other guys in the studio, and he was saying that the other guys got mad, but they never said who was at the studio.
But you're telling me, counsel, that you spoke with the witness prior to, and the witness is not saying she didn't say X, Y, and Z. She's saying she doesn't remember
Correct.
The incident.
In the presence of the witness and her attorney.
Thank you.
Your Honor, before I address the specifics there, I just want to put into the record some of the language that I think is most pertinent. In the Curtis case, 876 Southern 2nd 113, which was a First District case in 2004. This is the language. It says, Florida allows litigants to impeach their own witnesses, but that does not necessarily resolve the constitutional problem identified in Chambers, which is another case that's referenced. Although a witness may be impeached in Florida by any party, including the party calling the witness pursuant to Section 90.608 Florida statute, it is still improper under Florida law for a party to call a witness merely as a device to place the impeaching testimony before the jury. That is Curtis. In the Florida Supreme Court of Dudley, the language that we're relying on, the case says, one major issue requiring our consideration concerns the calling of Robert Bennett as a court witness and the presentation by the state of his prior inconsistent statement as substantive evidence. There's language further down. It says, in a similar situation, the First District Court of Appeals in Austin v. State, 461 Southern 2nd 1380, Florida, 1st District, 1984, found that although a witness's hostility towards the parties may justify the trial court's exercise of discretion in calling the witness as a court witness, call a witness only to elicit prior unsworn statements for the purpose of proving the truth of the prior statement is error. The district court stated, under the circumstances of this case, it was impermissible to use the expedient of calling the witness as a court witness under section 90.615 for the purpose of eliciting his prior inconsistent statement, either for impeachment purposes or as substantive evidence. To conclude otherwise would permit indirectly that which may not be done directly. Further language from that case says the fact that a witness may be hostile or unwilling does not mean that he is adverse. In order to be regarded as adverse under this section, the witness must give testimony prejudicial to the cause of the party calling it. So if you know that's what's coming in to begin with, there is no surprise. And then in the Felton v. State, 120 Southern 3rd, 126, 4th District, 2013, the language that we're relying on says, in Ruff v. State, 31, Southern 3rd, 833, Florida, 4th DCA, 2010, this court explained, our Supreme Court recognized that consistent with federal precedent, a risk of abuse occurs when a prosecutor calls a witness who has previously given a statement implicating the defendant, but who has since repudiated that statement. In such cases, the purpose of calling the witness must be examined along with the balancing analysis under Federal Rule 403 to weigh the prejudice over the probative value of the evidence. Generally, however, if a party, and that's citing to Morton v. State, 689, Southern 2nd, 259, Florida, 1997, that was receded from on other grounds. Generally, however, if a party knowingly calls a witness for the primary purpose of introducing a prior statement which otherwise would be inadmissible, impeachment should ordinarily be excluded. That is exactly what is taking place here. There's no failure of recollection. If the state, first of all, if somebody gets a call at 4 in the morning concerning a murder that occurred, you don't forget it. This notion that she forgot and she is now going to refresh her recollection by reading a statement into evidence that is impermissible, hearsay, is a pretext, and it is a 403 violation, and it is a violation of well-established law in this state that I've just articulated. And if the state was unable to refresh her recollection of such a significant event during preparation, the notion that she is now just going to read the statement into evidence on some pretext is a miscarriage of justice. If she has a witness, she has a witness. If she doesn't, and she knows she doesn't, calling the witness to impeach them by essentially introducing hearsay testimony is improper. The deposition that we took made clear that she she was receding from the statements that she made, and she gave explanations for why she made statements that she made. This is not a situation of failing recollection. This is a situation where they're trying to put in impermissible evidence under a pretext. And we object.
All right, anything else? Madam State?
No, Your Honor.
So we're going to bring the jury in. We're going to see where it goes. All right, I understand what the objection is. God bless. I understand what the objection is. We'll see where it goes.
All right.
All right, let's bring the jury in.
Those aren't the same statements that we're looking at.
No, we will have phone call, she's going to. Sure.
Your Honor, I'm not sure we're ready for the jury. We're being handed totally different information that they plan to
Gary, hold on.
put in through this witness.
I'm sorry, what were you handed, counsel?
Counsel has been handed and was previously provided in portion of the defendant's phone extraction. This particular summary, and there was a notice of intent to rely on summaries filed prior in this case by the state. This particular summary details the conversations between the defendant under the 772-713-9807 phone number, conversations with Mariah Hamilton, the witness's daughter, and her cell phone on that, as well as conversations with Miss Holmes herself, who is a party to some of these conversations. There was a group chat going on in which she is able to authenticate that the phone number, the 772-713-9807, which is reflected in those records, was being used by the defendant at times before, after, and during the homicide in question.
I take it these are just being introduced to identify the 9807 phone number
As well
as being a phone that Mr. Demons used.
Correct. So, and there's two first pages because if you look at them there's a section in green where he's telling Miss Hamilton this will be his third birthday he's been locked up on. I agree that that would be prejudicial to the defendant, so I created a version in which that specific item is taken out. So if you look at the green birthday and then just take the first page and the second page, or if you look at one another, with the exception of that alteration.
I'm not sure I understand. It sounds like you're saying these are conversations that took place while he was incarcerated?
No. He knew and was made aware he was going to be serving a sentence in Lee County because that was a negotiated resolution. So instead of saying third birthday I'm going to be locked up on, WTF, instead I just put third birthday and then her response on that.
To the extent that Ms. Holmes is not a party to the conversations, she can't authenticate. Now, I understand the state is saying that there are certain conversations which were a group conversation between Mr. Demons, Ms. Holmes, and Ms. Hamilton.
Correct.
Are all of those, do all of the conversations in that exhibit fit that description?
No, she's also identifying her daughter's phone number in this other one.
Identifying her daughter's phone number, Your Honor, doesn't identify the participants of a conversation.
And so here are the other ones in which, for example, there is other participants in which her daughter's phone number is included with the defendant, the 9807 phone number, the manager's phone number, the little brother's phone number, the phone number of Miss Janie King is on there. Then there's the phone number down here as part of the third part, where it is the defendant's phone number, Miss Hamilton, and Miss Holmes that are all listed on there.
And the state has not articulated a relevance of even establishing Ms. Holmes or Ms. Hamilton's phone number. For what purpose? I think I heard the state indicate a little while ago that there was no record, according to the detective, of this alleged phone call. So it's not as though they're going to say, see, here's a phone call between this number and that, because they don't have a record of it. So establishing the phone number, for what purpose? They might as well establish my phone number. What does it matter? If it can't be tied up, or if it's not going to be tied up to some other record that they have. Saying that we want to put it in to show her phone number. Show her phone number for what? What does Ms. Hamilton's phone number have to do with anything? They can proffer it, but they have not yet articulated it. And there's several phone conversations there. that do not involve the witness that they're about to call, and for those phone conversations to come in through that witness is just improper. How does she even lay the predicate to that?
Yes, ma'am, I don't know what you're trying to do.
So in terms of authenticating the phone numbers and laying the foundation for when these come in later on, I don't intend to publish these at this point. This is a predicate question that has to be established by this witness to show the phone numbers, the participants, the identity of those individuals, and some of the items in them.
When you say participants,
Correct.
does she know who the participants are? She's a party to this?
She is. She is one of the parties. For example, one of the specific items that's talked about is the defendant killed a pet. It was a snake that died. She knows and knows who had that snake, the circumstances of how it was killed, so she can authenticate based on the content who was on the other side, who was using that phone. The point of contention is who had the 772-713-9807 phone number at the time of the homicide.
Okay, thank you. All right, so we're going to just see where it goes. You make whatever objections you think are appropriate.
Okay, sir. Thank
I'm
you.
sorry, something funny?
Pardon me?
Something funny?
Not at your ruling. Your Honor, I mean no disrespect to you.
All right.
And
Let's bring the jury.
I hope you don't get that impression.
Let's bring the jury.
Thank you.
Jury entering. Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of the defendant. Dennis, his attorneys, assistant state attorney, the jury. Ladies and gentlemen, I apologize for the delay. My fault. Anybody else, I apologize for that. In any event, I think we're ready to proceed. So, Madam State, want to call your next witness, please?
State will call Felicia Holmes. And you're at this time, the state offers state triple J, which was previously shown to defense. Under 9803.6 is a business record. And request.
Any additional objections, counsel?
No additional objections, but objecting on the grounds previously raised.
Thank you. Please be admitted.
Thank you.
State's triple J will be marked state 61.
61?
61.
Thank you.
Counsel, where's your witness?
They were down the hall. With your permission, may I send you a text message, Ryan?
Yes. morning. Are you Ms. Holmes?
Yes, I am.
Welcome.
Hello.
Come on up here. This is our witness stand. Ms. Holmes, when you get there, what I'd like you to do is remain standing. Raise your right hand and be sworn. You get the first time. Thank you. Raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you should give in this case shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your full legal name for the record.
Felicia Ashe Holmes,
Please spell your first and last name for the court reporter.
FELICIA, HOLMZ.
Thank you.
Please have a seat. Ms. Holmes?
Yes, sir.
That microphone in front of you does not move back and forth. It will just up or down, but not back and forth.
Okay.
You ready?
Yes, sir.
Counsel, you may proceed.
Thank you. Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, I'm just, you know, I don't feel comfortable.
Are you nervous?
I feel threatened.
So, Ms. Holmes, I want to start and just talk about who you are.
Yes.
Ms. Holmes, do you have any children?
Yes, I do.
Can you tell the ladies and gentlemen of the jury who is Mariah Hamilton?
My youngest daughter.
And how old is Mariah?
She's 22 right now.
And Mariah, did she have a romantic relationship with someone named Jamel Denons, also known as YNW Melly?
Yes, she did.
When was she involved in that romantic relationship with Melly?
I'm thinking maybe about 2016 or so till maybe 2019, 20.
Okay. Did you have the opportunity to meet Mr. Denons?
Yes, I did.
What did you refer to him as?
I call him Jamel Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Your Honor, may the record reflect an in-court identification of the defendant.
Yes, the record will reflect an in-court identification of the defendant.
So in October of 2018, had you met the defendant prior?
Yes, I did.
How many times had you met him in person prior to that?
A couple.
A couple?
Maybe two maybe.
Okay. Did you follow him on social media?
I'm not sure. In 2018, I wasn't. No.
Okay. Did you know if he had social media at that time?
I didn't. No, I didn't.
Okay. Did you have a social media account at that time?
Yes, I did.
And what was your social media handle?
I'm sorry.
What was your social media name?
My name? For which one?
For Instagram.
Instagram. It's like Bling Queen 258.
Okay. Did you have a Snapchat at that time?
I don't think so. If I did, I may have.
Okay. What about your daughter? Did she have an Instagram?
I'm pretty sure she did.
Okay. Did she have Snapchat?
I'm pretty sure she did.
Okay. So I'm going to show you what's been already admitted into evidence as State 61. There's a couple of videos and things on that I would like to ask you to have some questions about.
Your Honor, we'd object as to the predicate being laid for this witness to testify to any of this material.
Thank you. Objection noted.
So I'm showing you what is titled Memories 2018 October 9th 4:58 UTC, Melly, Montana. Can you see that picture there on your screen?
Yes, I can.
Okay. Who is the female over there?
That's my daughter.
And which daughter is that?
Mariah.
Okay. Who else is in that photograph with her?
That's Chanel.
I want to go here to this image. This is 2018, November 11th, 23:53:26 UTC. Again, Melly, Montana. Who is pictured in this photograph?
My daughter Mariah.
Do you recognize the individual in the back?
No.
Prior to coming into court yesterday, were you shown two photographs of the alleged victims in this case?
Yes, I was.
Were you able to identify them?
No, I was not.
In terms of your relationship with Anthony Williams and Chris Thomas, how many times have you met them?
Maybe Zach maybe twice. Judy maybe once.
And do you know them by their real names?
No, I don't.
How did you refer to them?
Zach and Judy.
Okay. So I want to go forward to some of the videos in this particular exhibit, specifically Memories 2018, October 18th, 2:17:49 UTC. start with this one. I'm
Before
gonna.
we tell me all that extra shit, and like, they leave the most important shit here. Then,
So the image that is shown there. Do you recognize the person in that driver's license?
It's blurry.
Okay. I'm going to show you another video, the next one
the most
here.
important shit here. Like, get right there, like, you know you come back.
Whose driver's license is that?
That's my daughter.
The conversations and things that on there, do you recognize the voice?
I didn't really listen. I mean, you have to play it again.
Sure.
Before we tell me all that extra shit, and like, they leave the most important shit here. Then,
Do you recognize the person who's speaking in that video?
Yes, I do.
Who is that?
That's Jamel.
Okay. So I want to go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I did.
And who is she?
Jamie.
Have you met her prior to October 26th of 2018?
Yes, I have.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you to.
I don't know if I did or not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about that early morning hours. Did you receive or hear a phone call or FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Okay. Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hearing my daughter's voice.
Okay. What was she? What was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2018?
I read the statement.
Okay.
Was it? I don't recall. I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Okay. I want to go, and when you spoke, you remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone.
Okay. So, Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018. I went through a lot during that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. But I don't remember what I said back. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So, in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Like I said, 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter to take her to jail for accessory after that. I do remember that.
Yes. And in terms of the statements that you made about what happened, you don't have any recollection of that? Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't know.
And so you indicated you hoped you were truthful with law enforcement?
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie on the stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
Objection, asked and answered. Excuse me, overruled. Repeat your question.
I don't remember.
Excuse me.
Yes, sir.
Only one person can talk at a time, and there was an objection. I just wanted to be
Okay.
clear. All right, you asked your question again.
Okay, so Ms. Holmes, did you lie to law enforcement?
Not that I recall.
Okay.
I don't remember.
Okay, going forward to the events of that day,
Yes.
when you heard that phone call, where were you?
I'm home.
Okay, where was it? Home in Cocoa?
Cocoa.
Who else was there at your house?
My kids.
When you heard the phone call, did you hear what had allegedly happened?
I heard that there might have been a shooting.
Okay. Did you see any pictures or videos of anyone that was injured at that point?
No, I did not.
Did you see the defendant on the screen of that video call?
I saw his face, yes.
In terms of the method of communication, do you know if it was a FaceTime call?
I assumed it was FaceTime. I couldn't say for sure what kind of call it was.
At the time of October of 2018 through December of 2018, did you know the defendant's phone number?
No, I don't.
Do you recall today what the defendant's phone number was?
No, I don't.
Okay. In terms of the information and stuff that you have regarding that phone number, was that saved in your phone at that time?
It may have been. I can't remember.
Do you remember what phone number you had?
No, I don't. No, I don't.
So, Ms. Holmes, to go back in terms of looking at your statement or any of the other things, refresh your recollection as to what the defendant's phone number was and what you had at that time.
I'm sorry, could you repeat the question?
Sure. You said you didn't remember the defendant's phone number.
No, I don't.
Would looking at a copy of your statement help refresh your memory as to what?
No, I don't think it would.
Okay. Would you like to try to do so?
You have to look at it for you, sure.
Okay. And so, counsel, on for the record, I'm showing her page 3 of 8. And I'm going to ask you, Ms. Holmes, to just read this part silently to yourself.
Okay.
And I'm going to we're going to start here, this, and through here, okay? Silently to yourself. When reviewing that, does that refresh your recollection?
No, it doesn't.
Your Honor, pursuant to 90.8035, the state would move at this time to read into the record the relevant portions.
Objection.
Can I see, please?
Yes, Your Honor.
Ladies and gentlemen, it's 12 o'clock. Let's take our lunch and recess. Don't discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in the presence. There's certainly no research, all right? Leave the notepad on your chair. Sorry for the delay.
What time?
Let's say 1:30. Thank you.
Ms. Holmes? Stand.
Oh, sorry.
Right there, thank you.
Thank you. Let the record reflect the jury stepped out. Counsel remained along with the defendant, assistant state attorneys, and our witness. Madam, you want to step outside for a minute? Thank you. Just wait outside. Thank you. So what do you anticipate this?
That her answer would start with, he FaceTimed my daughter from the 772 number. Question, yeah. Answer, unless he got rid of that phone. He FaceTimed my daughter that morning at 4 a.m. in the morning, yeah. Question, what's your daughter's number? Her number is 506-321-506-1313. But she may have another number because I changed her. She lost her cell phone and got another number. Her old number was, question, no, cuz, answer. Her old number was 877-9609-321. Question, no. See, I have his phone records and you know, he never called it. There was never, answer. You have the 772-713-9807? Question. 9807. Answer. I don't know whose phone that he called and FaceTimed with. I talked to him on FaceTime.
So, assuming that I let this portion in, is this going to be a reoccurring theme that, what else are you going to ask her about?
In terms of that, as well as the initial part where she says she doesn't recall what he said verbatim. That would be the part where he's saying that someone just shot the car up and was trying to shoot them. So I asked him if he was okay, where he was, and he's like, there's a car coming behind him, like hiding. He was like, there's some, there's some. I think they're still out here or something. So I'm like, are you okay? He's like, I'm okay. I said, well, where are Sack and Juby? And he said, I don't know if they're in the car. I think they're dead.
And that's the portion that you're looking to have admitted?
So far, based on her current state of her testimony up to this point.
Is there anything else?
If there's anything else that she doesn't remember on that, for example, the Frito Bang or Frederick Bivens is his actual name, aspects of that, anything about the condo in Miami, about the blood on the clothes. There's another part later on where she then describes the conversation again that he said. He just basically said that his friend they just got killed, and that he was like, there was lights coming, somebody's coming, someone's coming. I'm like, are they still out there, you know? Question, answer. It's like I don't know. And I said, we're on our way, just so you know, stay put, we'll come get you. So at this time, I'm thinking he's somewhere hiding in the bushes somewhere from whoever shot him.
And the statement goes on, there's other things that you're trying to get out through this witness that you're concerned that she may or may not remember?
Those are the relevant portions, Your Honor. There's a lot of other things that she indicates in the statement that I would agree would not be relevant, and that wouldn't prove an essential fact that is at issue in this case. So I would not be seeking to insert the entire statement.
Basically the portions that you just elicited.
Yes,
correct?
sir. And I can I have the ability to, in a Word document, to isolate those so that they can be succinctly read, provided to defense as well, so they would have copies. But the case law is clear and the statute is clear. The state cannot introduce that statement, but defense would be able to if they so chose.
Thank you. And your objection is?
Your Honor, we have a copy of her deposition, which makes clear.
Can I stop you for a second?
I'm sorry.
What is counsel reading from now? What are you reading from now?
I am reading from her statement of December 12th of 2018.
You're reading from the statement, not the deposition?
Correct.
Thank you. I'm sorry. Go ahead.
Thank you. And before I go any further, Your Honor, I meant no disrespect. And I appreciate your and understand your authority, and you're making decisions. Whatever reaction I had was not intended to convey disrespect, whether I agree with your decisions or not. Her deposition of December 14th, 2022 will clarify the issue of whether this is a failure of recollection that the state is trying to refresh, or whether or not this witness has recanted her statement and is making an entirely different statement about the facts of that night. In this deposition, she is not claiming not to recall. She said she wasn't certain about the time of the call, but she quickly got herself together and came down here, and it took about 3 to 4 hours, like she said, and she got here around 12 or 1 o'clock, which would place that call at 8 or 9 o'clock in the morning. There are several other substantive statements that indicate that she is recanting that statement she gave on that day. She says the reason that she gave the statement was because her daughter was threatened with arrest, like she said here. She said that she feels threatened, and first thing she said there, she's not talking about Jamel, she's talking about the state. She's on an ankle bracelet. They arrested her in the Virgin Islands and brought her over here. And the statements she's making in her deposition do not support and are I wouldn't say they contradict, but they're not the statements that are made in the statement that the state seeks to elicit. If the rules allowed her to put a witness on just to get in a prior statement, then they'd be in okay territory. The rules don't permit that. She's creating this pretext. Oh, you forgot that? Well, let me read it into the record. I would offer the court a copy of this deposition over lunch to review that makes it clear that she is recanting. She is not forgetting. She is recanting. And that's exactly what these cases speak to, and the process that the state is, what they're attempting to engage in is to violate and circumvent the rule and admit out-of-court statements for the truth of the matter asserted, which are hearsay, which are recognized to create constitutional problems, which have resulted in some of these cases and murder cases being reversed, murder convictions being reversed, and she's inviting error into this court, into this trial, and we'd ask the court to at least get a context of what is going on here, whether this is a failure of recollection, whether that's the way she's fashioning it, or whether or not what she said in her deposition does not comport with what she said in that statement that she's recanting, and whether the state is just using this rule as a pretext to get the statements that they're not permitted to get.
Thank you. You have the statement of Ms. Holmes as well?
I do, Your
And that
Honor.
was taken under oath?
It was, yes, it's a sworn statement from Ms. Oath, from Ms. Holmes in December of 2018. And Your Honor, I would also add that some of the time frame and issues of that, those were actually clarified because defense provided the state with reciprocal discovery of Ms. Janie King's phone records, which authenticate the statements, for example, that Felicia Holmes said she immediately called Janie King. That is shown in Ms. King's phone records.
Who's Jamie King?
The defendant's mother. So there's outside sources that corroborate the sum and substance of her December 2018 statement.
All right, so I'm going to take the statement. If there's no objection, I'll take the statement and the deposition. I'll read those over lunch, and then see everybody back here at 1:15. I told the jury to be back at 1:30. We'll resolve those issues, and we'll move forward. All right?
Thank you, Judge.
Thank you.
Romantic relationship with someone named Jamel Denons, also known as YNW Melly.
Yes, she did.
When was she involved in that romantic relationship with Melly?
I think it may be about 2016 or so till maybe 2019, 20.
Okay. Did you have the opportunity to meet Mr. Denons?
Yes, I did.
What did you refer to him as?
I called him Jamel Melly.
You see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Your Honor, may the record reflect a court identification of the defendant.
Yes, the record will. will reflect an in-court identification of the defendant.
So in October of 2018, had you met the defendant prior?
Yes, I did.
How many times had you met him in person prior to that?
A couple,
A couple?
maybe two maybe.
Okay. Did you follow him on social media?
I'm not sure. In 2018, I wasn't. No.
Okay. Did you know if he had social media at that time?
I didn't. No, I didn't.
Okay. Did you have a social media account at that time?
Yes, I did.
And what was your social media handle?
I'm sorry.
What was your social media name?
My name? For which one?
For Instagram.
Instagram. It's like Bling Queen 258.
Okay. Did you have a Snapchat at that time?
I don't think so. If I did, I may have.
Okay. What about your daughter? Did she have an Instagram?
I'm pretty sure she did.
Okay. Did she have Snapchat?
I'm pretty sure she did.
Okay. So I'm going to show you what's been already admitted into evidence as State 61. There's a couple of videos and things on that I would like to ask you to ask some questions about.
Your Honor, we'd object as to the predicate being laid for this witness to testify to any of this material.
Thank you. Objection noted.
So I'm showing you what is titled Memories 2018 October 9th 4:58 UTC, Melly, Montana. Can you see that picture there on your screen?
Yes, I can.
Okay. Who is the female over there?
That's my daughter.
And which daughter is that?
Mariah.
Okay. Who else is in that photograph with her?
That's Chanel.
I want to go here to this image. This is 2018, November 11th, 23:53:26 UTC. Again, Melly, Montana. Who is pictured in this photograph?
My daughter Mariah.
Do you recognize the individual in the back?
No.
Okay. Prior to coming into court yesterday, were you shown two photographs of the alleged victims in this case?
Yes, I was.
Were you able to identify them?
No, I was not.
In terms of your relationship with Anthony Williams and Chris Thomas, how many times have you met them?
Maybe Zach maybe twice. Judy maybe once.
And do you know them by their real names?
No, I don't.
How did you refer to them?
Zach and Judy.
Okay. So I want to go forward to some of the videos in this particular exhibit, specifically Memories 2018, October 18th, 2:17:49 UTC. Start with this one. I'm going to...
All that extra shit, and like, they leave the most important shit here.
So the image that is shown there, do you recognize the person in that driver's license?
It's blurry.
Okay. I'm going to show you another video, the next one here.
Like, get right there, like, you know you come back.
Whose driver's license is that?
That's my daughter.
The conversations and things that on there, do you recognize the voice?
I didn't really listen. I mean, you have to play it again.
Sure.
Before you tell me all that extra shit, and like, they leave the most important shit here.
Do you recognize the person who's speaking in that video?
Yes, I do.
Who is that?
That's Chanel.
Okay.
And so that was just a portion of the testimony from Felicia Holmes, the mother of the defendant's ex-girlfriend there. Sonny, I'm going to start with you here. Felicia Holmes mentioned at the beginning of her testimony that she felt threatened. How would you assess that, and what could a jury be reacting to hearing that?
I think when she said that, and as I heard her say that, I think she was scared about testifying, scared that she might suffer some repercussions from that. And the jury's probably wondering, why would she say those particular words? Why does she feel like her life might be in danger? And what is it that has happened prior to her saying that, or prior to this incident, that makes her feel so threatened? Either her presence, his presence, or what is really going on. So I think that's worth them unpacking later on.
And Bob, do you think Holmes comes off as a reluctant witness here?
In the beginning, she doesn't. She seems to be, very compliant, but there's obviously discomfort that she has in testifying here. So, and as she's going to get walked through these tapes and what apparently are admissions relating to this crime that the defendant's charged with, and the gang overtones that are behind the scenes of this trial, whether they actually come in or enter the trial is another question. Those are things that I think the jury's going to look at, because demeanor, credibility, and what weight to give that are going to be very important in terms of what evidence they're going to accept and how heavily they're going to rely on it.
Yeah, I certainly felt she gave off some type of vibe that she was a little hesitant and holding back on how she really felt with the whole situation. All right, we're going to have to get a quick break here, but clearly a very busy day in court in the Melly trial. Keep in mind that we are going to have a Q&A session as well on this trial coming up around 12:30 p.m., so that's soon. So get your questions ready on social media. We'll be right back with more. You're watching Law and Crime.